Okay, everyone, this is our final video of the week. So, we are continuing to talk about civil liberties. And the freedom of the press is one liberty that had been kind of constrained before. Now, remember the Alien and Sedition Acts? This was the first major test of the freedom of the press, and preventing the publication of something was declared unconstitutional. Now, the restrictions on free speech, these are the only ones that apply to the press. So the press cannot publish obscenity. Now, can the government regulate obscenity? Yes, but it has to be truly obscene. The average person must find the material appealing to prurient interest, that is lustful. So basically, print media, the media, they can't publish pornography. But state law has to define what obscene is. And the work as a whole has to lack any serious literary, artistic, political, or scientific value. So, in the 19th century, civil liberties are really bound up in the concept of property rights. And I'm just going to do this because it's going to interrupt my flow otherwise. Let's come back. So, early Americans worried a lot about the loss of property. And this leads to the support of contract law. So, contract law means that a contract between individuals cannot be violated. Now, under the Marshall Court, the right to property expands and contracts are strengthened. Even a fraudulent contract was still a contract and government could not violate it. And it was ruled states cannot modify an existing contract. So there's a lot of text on this page. If you want to pause the video and read all of this, by all means, go ahead. But here's Fletcher v. Peck. So, 1979, Georgia state legislature passes a land grant which awards territory to four companies. The following year, though, the legislature voided that law and declared all rights and claims under it to be invalid. Now, in 1800, 5 years after the Georgia legislature passed this original law, 4 years after they canceled that original law, Jonathan Peck acquired land that was part of that original legislative grant. He then sold it to Robert Fletcher 3 years later, claiming that past sale of the land had been legitimate. Fletcher argued that since the original sale of the land had been declared invalid, Peck had no right to sell the land and thus committed a breach of contract. So, could the contract between Fletcher and Peck be invalidated by an act of the Georgia legislature? The conclusion was no, it could not. This is a unanimous opinion, and the court held that since the state had been legally passed into the hands of the purchaser for valuable consideration, the Georgia legislature could not take away the land or invalidate the contract. Noting that the Constitution did not permit bills of attainder or ex pacto laws, the court held that laws annulling contracts or grants made by previous legislative grants was unconstitutional. Dartmouth College v. Woodward. 1816, the New Hampshire legislature attempted to change Dartmouth College, a private institution, into a state university. The legislature changed the school's corporate charter by transferring the control of trustee appointments to the governor. And in an attempt to regain authority over the resources of Dartmouth College, the old trustees filed a suit against Woodward, who sided with the new appointees. So, did the New Hampshire legislature unconstitutionally violate and interfere with Dartmouth College rights? Yes, was the decision. In a 6-1 decision, the Supreme Court held that the college's corporate charter qualified as a contract between private parties, and the legislature could not interfere with that. The fact that the government had commissioned the charter did not transfer the school into a public institution. Justice Marshall's opinion emphasized that the term contract referred to transactions involving individual property rights, not to the political relations between government and its citizens. Going to do this again. So there is another advancement of property rights under the Taney Court, and this one's heavier because in this case Dred Scott, who was a slave, moved with his owner to a free state, and attempted to sue for his freedom. He lost, and this is where things get really dark. The court says that if he were to be freed, that the states would be violating commerce laws. And what this does is this voids the Missouri Compromise, which had kind of set out that any slaves could not move to a free state, that slave states could not expand. But now slave owners can take their slaves with them into so called free states. This voids the entire purpose of the Missouri Compromise, and it really adds a lot of tension between abolitionists and non abolitionists. So here are some of the facts of the case. You can see this. He sues unsuccessfully in Missouri courts, claiming that his residence in a free territory made him a free man. The problem is that the courts determined that Mr. Scott was still property. He was a slave. So under Articles 3 and 4, no one but a citizen of the United States could be a citizen. Only Congress could confer national citizenship, hence the 14th Amendment many years later. Taney reaches the conclusion that no one person descended from an African slave had ever been a citizen of Article 3. Again, all of this adds fuel to the fire in terms of why the 14th Amendment was passed. Now, civil rights. There are 7 steps to winning political equality. A group defines itself. A group comes together with a core identity and a core mission. And then that group challenges society. They enter the political arena and they demand rights. This is your social movement stage. Now, the stories have changed. Society's idea of a group changes. Society warms up to the civil rights movement and to the freedom riders. Society warms up to the women's suffrage movement and feminist movements. Society warms up to LGBT activist groups. Now federalism comes into play. First, the movement can gain some recognition in smaller areas and then become the law of the land slowly. This is the case with gay marriage, which was a very incremental process. States legalized gay marriage. No one was really certain how long these states would keep gay marriage legal, so it's a step-by-step process. Ooh, okay, one more. 14th Amendment, freed slaves. We talked about that. No state made to private. We're going to talk about that. Okay, I think that this about covers everything. So I'm going to let you guys go. Stay rooting, stay tooting. By God, stay safely shooting. But most of all, be kind. Y'all have a great week. I'm looking forward to seeing you in class in person.